The 26th Amendment holds a record nobody talks about. It went from proposed by Congress to ratified by 3/4 of the states in about 3 months, 100 days, give or take. It is the fastest ratification in American history, and nothing else is close. Compare that to the amendment we covered in the episode on congressional pay, which took 202 years. Or women's suffrage, which took 72 years from Seneca Falls. This one took 100 days. Something had to have gone very wrong, very publicly, for the country to move that fast. And something had. The text is short and familiar in shape by now. The right of citizens of the United States, who are 18 years of age or older, to vote shall not be denied or abridged by the United States or by any state on account of age. Same architecture as the 15th and the 19th. A prohibition on one ground of exclusion, plus a congressional enforcement power. Not a grant of the franchise, not a guarantee, just age cannot be the reason once you are 18. So the question for this primer is not what it means, it is why it exists at all, and why it had to be an amendment. Because Congress had already tried to do this by statute, and the Supreme Court had just told it that it could only do half the job. This is Do It for the Case Law. Doctrine Deep Dives, Season 0, the amendments one at a time, one sharpest gap each. Today, the 26th. Before the pressure, a word about where the voting age came from in the first place, because nobody chose 21 deliberately. It was inherited. 21 was the age of majority in English common law, and the colonies carried it over without much examination, and the states kept it. There is no founding-era debate about whether 21 was the right number for the franchise, because it was not treated as a question. It was simply what adulthood meant. That matters for how the later argument played out. The defenders of 21 were not defending a considered judgment about political maturity. They were defending a convention whose origins nobody could articulate, which is a weak position to hold once someone makes a concrete argument on the other side. And it is part of why the thing collapsed so quickly once it started moving. It is also worth noticing which way the draft argument actually cut, because it was not as one-sided as the slogan suggests. Opponents of lowering the age had a real response available, and they made it. Conscription, they argued, is a duty the state imposes on the physically capable, and physical capability at 18 tells you nothing about political judgment at 18. The two are simply different questions, and the slogan collapses them. That is not a foolish argument. It is the same structure as the response to any consistency claim, pointing out that the two things being compared were never measuring the same thing. What defeated it was not a better counterargument. It was that the state was asking 18-year-olds to die in a war that was itself deeply contested, and the optics of denying those same people a vote on it were unsustainable regardless of the logic. Start with the pressure that built it, because it was real and it was specific. Through the 1960s, the voting age in most states was 21. At the same time, men were being drafted at 18 and sent to fight in Vietnam. The argument that followed wrote itself, and it was made loudly and constantly: old enough to fight, old enough to vote. It is worth pausing on how narrow that argument actually is. It is not a claim about political maturity in general, it is a claim about consistency. The state has decided you are adult enough to be conscripted and to die, and it has simultaneously decided you are not adult enough to have a say in who makes that decision. Those two judgments cannot both be right. That inconsistency is what moved the country, and it moved it fast once it moved at all. Congress acted first, and it acted by ordinary statute rather than by amendment. In 1970, it amended the Voting Rights Act to lower the voting age to 18 in all elections, federal, state, and local. That is a large claim of power, and it was immediately challenged. The question was whether Congress could set the voting age for state and local elections at all, or whether that belongs to the states. And here's where the story turns, because the answer the Supreme Court gave in Oregon versus Mitchell, decided in December of 1970, is one of the strangest dispositions in the court's history. There had also been earlier attempts, and knowing about them sharpens why 1971 worked. Georgia lowered its voting age to 18 during the Second World War, on essentially the same reasoning that would later carry the amendment. Kentucky followed. A few other states moved over the following decades. Presidents from both parties endorsed the idea publicly across the 1950s and 60s, so this was not a new proposal that suddenly persuaded people. It had been endorsed at the highest level, adopted by individual states, and argued in Congress for roughly 30 years without becoming national law. 30 years of agreement, and nothing. Then 100 days. The variable was not persuasion. The court split so badly that there was no majority opinion. Instead, there was a fractured judgment in which one justice's position controlled the outcome by sitting between two blocks of 4. The result was a division down the middle of the statute. Congress could lower the voting age to 18 for federal elections. Congress could not lower it for state and local elections. Sit with what that produced in practice. As of that ruling, a state that kept its voting age at 21 would have to run two sets of voter rolls, one listing everyone 18 and over, eligible to vote for president and Congress, and another listing only those 21 and over, eligible to vote for governor, legislature, mayor, and everything else on the same ballot. That is not a doctrinal abstraction, that is an administrative catastrophe arriving on a fixed date. Every affected state would need dual registration systems, dual poll books, and in many cases separate ballots. For the 1972 elections, election officials said so immediately and loudly. The cost estimates were significant and the timeline was short. So the country now had a problem that was not really about political philosophy at all. Whatever anyone thought about 18-year-olds voting, nobody wanted to run split elections. And there was exactly one way to make the problem disappear. Put the age in the Constitution, where it would apply to every election at every level, and the split would never happen. It is worth being precise about what the court actually decided, because the fracture is the point and it is easy to flatten. There were several distinct questions in the case, and the justices divided differently on each. On lowering the voting age, 4 took the view that Congress could set it for all elections. 4 took the view that Congress could set it for none. The deciding vote split the difference, concluding that Congress had authority over federal elections, but not over state and local ones. So the controlling rule was a position that commanded exactly one vote. 8 justices thought it was wrong in one direction or the other, and that single-vote compromise became the law of the land, and immediately created a problem that neither of the other 2 positions would have created. A unified answer either way would have been administrable, only the middle produced chaos. There is one more feature of the ratification worth marking, because it is genuinely unusual. The amendment passed the Senate unanimously and the House by an overwhelming margin, and then no state legislature that took it up rejected it. 38 states ratified, and the process simply did not encounter meaningful opposition anywhere. That essentially never happens. Every other significant amendment in the modern era has had organized opposition, contested state votes, and a real possibility of failure. This one had none. Which tells you the political question had actually been settled well before 1971. What had not been settled was the mechanism, and the court's decision supplied the reason to finally use the right one. The country had agreed for years. It just had not been forced to act on the agreement, which is precisely what happened, and it explains the 100 days. Congress proposed the amendment in March of 1971. The states ratified it by the beginning of July. The speed was not primarily a burst of enthusiasm for youth enfranchisement. Though that existed too, it was a deadline. The 1972 election was coming, the dual roles problem was concrete and expensive, and an amendment was the only clean fix. So the fastest ratification in American history was driven substantially by administrative necessity. That is less inspiring than the version people usually tell, and it is more instructive because it says something about what actually makes constitutional change move. Here is that lesson stated plainly because it recurs across this whole season. The moral argument for lowering the voting age had been available and unanswered for years. It did not produce an amendment. What produced an amendment was a Supreme Court decision that created an immediate, expensive, unavoidable practical problem for the people who administer elections. Constitutional change in this country tends to happen when a principled argument finally coincides with an operational emergency. The argument alone rarely suffices, and the emergency alone would not have pointed toward 18. It took both, arriving together. The 26th Amendment is the cleanest example in the Constitution of that combination because the gap between the two was only about 4 months, and the timing made it worse in a way worth spelling out. The decision came down on the 21st of December 1970. State legislatures in most places would convene in January, would sit for a matter of months, and would then adjourn. The 1972 primaries would begin in the spring of that year, so election officials had roughly one legislative session to build a dual registration system, or the states had one legislative session to ratify a constitutional amendment. Those were the two options, and the second was cheaper and permanent. When people describe the 100-day ratification as a wave of enthusiasm, that is not wrong exactly, but it leaves out that the legislatures had a narrow window and a clear alternative, and they took the cheaper one. Now, what has the amendment actually done since? Like the 19th, it has generated very little litigation about its core meaning. Nobody seriously argues about whether a state may set its voting age at 21. The text forecloses it and no one is trying. Where it has been raised is at the edges, in cases about rules that do not mention age but fall differently on younger voters, student identification rules, registration deadlines timed against academic calendars, polling locations on or off campus. Those arguments invoke the second half of the text, the words denied or abridged, and ask whether a facially neutral rule abridges on account of age. That is a live area, and it is worth flagging that it is unsettled rather than pretending otherwise. And notice the shape of that unsettledness, because it should be familiar. It is exactly the question the 15th Amendment spent a century on. Does a prohibition on one ground reach facially neutral rules that operate on that ground in practice, or only rules that name it? Every one of these voting amendments eventually arrives at that question, because every one of them is drafted the same way. Forbid a stated reason, and you have not addressed any mechanism that produces the same exclusion without stating it. The 15th got a definitive answer only when Congress built the Voting Rights Act. The 26th has never had that, because the exclusion it forbids has never had an entrenched constituency working to reconstruct it. But the doctrinal question underneath is identical, and it has not gone away. There is a further consequence of that history that deserves saying because it cuts against the tidy narrative. The amendment enfranchised roughly 11 million people essentially overnight, the largest single expansion of the American electorate since the 19th Amendment. That is an enormous democratic event, and turnout among newly eligible voters in 1972 and in the decades since has consistently been the lowest of any age group. The enfranchisement was real and immediate, the participation was not, which is a genuine puzzle rather than a criticism, and it is one this amendment cannot answer. Removing a legal barrier to voting and producing voters are different things, and the Constitution can only do the first. Everything determining whether people actually vote sits outside the text entirely. There is a second thing worth noticing, which is what the amendment did not do. It set a floor, not a ceiling. It says a state may not deny the vote to someone 18 or older on account of age. It says nothing preventing a state from going lower. A state that wished to enfranchise 16-year-olds in its own elections is not barred by this amendment from doing so, and a small number of municipalities have done exactly that for local races. So the amendment nationalized a minimum and left the space below it to the states. That is the same structure as most of the Constitution's voting provisions, a federal floor with state variation above and, where the text permits, below it. The student voting cases are worth a little more detail because they are where this amendment is actually contested now. The recurring pattern is a rule that says nothing about age but lands disproportionately on personlijke utility for cases of action to fries, and that involves
the shaking out a registration deadline that falls before a semester begins, the placement or removal of a polling site on a campus residency rules that treat a dormitory as a temporary address. Each of those has a facially neutral justification available, and each of them in practice makes voting harder for a population defined largely by its age, whether the words denied or abridged reach that is genuinely open.
Set this amendment against the 24th for a moment because they are close cousins and the comparison is clarifying. The 24th, ratified in 1964, forbade poll taxes in federal elections. Notice the limitation, federal elections only. It left state poll taxes standing, and it took a separate Supreme Court decision 2 years later to reach those under the 14th Amendment. So the 24th had exactly the split coverage problem that the 26th was written to avoid, and the country lived with it for 2 years rather than amending again. The difference is that a poll tax applies to a small and shrinking set of voters, so the split was tolerable. An age line applies to everyone all at once on the same ballot. The scale of the inconsistency is what made it intolerable, and intolerable is what produces amendments. And the amendment did not settle the question it is usually said to have settled, which is whether 18 is the right age. The old enough to fight argument was about consistency with conscription. Conscription ended in the United States in 1973. 2 years after ratification, the argument that produced the amendment therefore stopped applying almost immediately after it succeeded. That is not a reason to reopen the question. But it is worth noticing that the constitutional rule outlived its own principled justification by half a century, and that nobody has felt the need to supply a replacement. Once a rule is in the text, the argument that produced it stops being load-bearing. The rule simply is. And a final structural note, which is about what all 4 voting amendments share and what it implies. Each of them is a prohibition plus an enforcement clause, and each enforcement clause is worded identically. Congress shall have power to enforce this article by appropriate legislation. Congress has used that power seriously exactly once for the 15th Amendment in 1965. It has never enacted comparable machinery under the 19th, the 24th, or the 26th, which means 3 of the 4 voting amendments are operating on their bare text alone with no statutory framework behind them. They have been effective anyway because nothing has seriously tested them, but the tool exists unused in all 3. If the neutral rule question under the 26th ever becomes urgent, the answer already available is the one that worked in 1965. Congress can legislate. And notice the asymmetry with the 15th Amendment that makes this harder rather than easier. With race, there is a century of doctrine about facially neutral devices, a statutory framework built specifically to reach them, and a long evidentiary record establishing what evasion looks like. Courts have tools. With age, there is almost nothing. The 26th has no Voting Rights Act behind it, no accumulated body of cases distinguishing legitimate rules from pretextual ones, and no established method for proving that a neutral rule operates on age. A litigant raising the claim is largely working from first principles. So the same doctrinal question that took the 15th Amendment 95 years and an act of Congress to resolve is for the 26th still essentially unaddressed. So here is the thesis, and it is about how constitutional change actually happens rather than about age. The 26th Amendment exists because the Supreme Court cut a statute in half and left an administrative mess that only a constitutional amendment could clean up. The moral argument had been made for years without result. The mess produced results in 100 days. And the mechanism generalizes. When people ask why some constitutional change happens and other change does not, the usual answers are about public opinion or political will. Those matter. But the 26th suggests something narrower and more mechanical change moves fastest when the status quo becomes operationally impossible for the institutions that have to run it. Make the current arrangement unworkable for the people administering it, and the amendment writes itself. That framing also explains the amendments that have not happened. Proposals that would change how elections work in ways the existing machinery can absorb tend to stall indefinitely, however strong the argument. Nothing breaks if they fail. The people who would have to implement them are not facing a deadline. The 26th had a date on the calendar, a set of officials who could not comply, and a bill attached. That is a different kind of pressure from persuasion, and it is the kind that produced the only 100-day ratification in American history, which is worth remembering both ways. It tells you what it takes to move the Constitution. It also tells you that the Constitution mostly does not move, because that combination is rare. One more thing worth carrying out of this episode, about what the 100 days cost. Speed in constitutional drafting is not free. The 26th was written quickly, passed quickly, and ratified quickly, and it shows. It says nothing about enforcement mechanisms beyond the standard clause, nothing about what abridgment means, and nothing anticipating the neutral rule problem that is now its main live question. Compare that to amendments drafted over years of argument, which tend to carry more internal machinery. The 26th is a single sentence solving a single crisis, and it solved that crisis completely. But it left the harder questions for later, and later has arrived without any of the tools that would help answer them. Fast is not the same as finished. And there is a closing observation that ties this episode to the rest of the season. 4 amendments forbid 4 grounds for denying the vote: race, sex, poll taxes, age. Read them side by side and they are almost the same sentence 4 times. What differs is not the drafting but the history each one landed in. Race had an apparatus built to defeat it, and the prohibition took a century and a statute to become real. Sex, poll taxes, and age had no comparable apparatus, and those prohibitions worked quickly. So if you want to know what a voting rights provision will actually deliver, the text will not tell you. The question is always what is standing behind the exclusion and whether anyone is still willing to rebuild it after the stated reason is taken away. That is the sample. A full Amendment 26 season on this show would take the strands separately: the draft age argument and the decade of campaigning behind it, Oregon versus Mitchell, and how a fractured court produced a judgment nobody had argued for the 100-day ratification, and the administrative pressure driving at the modern student voting cases, and whether denied or abridged reaches facially neutral rules and the floor not ceiling structure that leaves room below 18. One question per episode, each anchored in cases we verify, not cases we remember. A word on how this show works. Everything you just heard is legal and historical education, not legal advice, and the case at the center of it is real, named, and verified. Oregon versus Mitchell is a genuine decision of the Supreme Court from December of 1970, and its split disposition upholding the 18-year-old vote for federal elections while rejecting it for state and local ones is described here from the opinion itself. Where we summarize rather than quote, we say so. That is the whole ethos, and it is the name of the show. Do it for the case law. I'll see you at the next amendment.